$67 million for a pair of pants. That's not a typo. In 2007, a Washington D.C. judge sued a small dry cleaning business for $67 million because they lost his pants. This case became the ultimate symbol of America's lawsuit culture gone mad. It made international headlines. Late-night comedians couldn't stop talking about it. Legal experts debated it on national television. And it sparked a fierce conversation about justice, fairness, and whether the legal system had completely lost its mind. Not rare pants, not designer pants, just regular gray dress pants, probably worth about $40. The judge's name was Roy Pearson. The family he sued, Jin Nam and Sue Chung, Korean immigrants who owned custom cleaners. This case made international headlines. Late-night comedians told jokes about it. Legal experts debated it on TV. It became the poster child for everything people hate about frivolous lawsuits. But here's what makes it truly fascinating. Judge Pearson genuinely believed he deserved that money. He had calculations, legal theories, a meticulous case built on consumer protection laws. And the Chungs, they offered to settle multiple times for $1,200 for one pair of pants. He said no, because this wasn't about pants anymore. This was about principle, about a sign that hung in their window. 3 words that would cost this family everything. Satisfaction guaranteed. This is the true story of the pants lawsuit, how it started, how it escalated, and how it ended with nobody winning. Let's go back to where it began. May 2005, spring in Washington, D.C. Judge Roy Pearson walked into Custom Cleaners with several items that needed alterations. Among them, a pair of gray suit pants. He handed them to the Chungs. They tagged the items, wrote up a ticket, set a pickup date, routine transaction. Happened 1,000 times a day in dry cleaners across America. But when Pearson returned to pick up his items, one pair of pants was missing. The Chungs apologized. They searched everywhere. They were embarrassed and concerned. A few days later, they found a pair of gray pants matching the description. They called Pearson immediately. He came to look at them, examined them carefully, and said 4 words that would change everything. These aren't my pants. The Chungs were confused. The tag matched. The description matched. How could these not be his pants? Pearson insisted. Wrong pants. Someone made a mistake, or worse, was trying to deceive him. The Chungs offered solutions. A refund, store credit, money for new pants. They offered $50, then $150, then $300, then $1,200, $1,200 for a pair of pants. Pearson refused every offer because he'd noticed something, that sign in the window. Satisfaction guaranteed, and he was not satisfied. What happened next would cost the Chungs over $100,000 in legal fees, destroy their health, damage their business, and make them famous for all the wrong reasons. This is that story. To understand how this situation spiraled so completely out of control, you need to understand Roy Pearson. He was an administrative law judge in his 50s, intelligent, well-educated, successful. But colleagues noticed something: extreme rigidity. He saw the world in absolutes, right or wrong, black or white, no gray area. A recent difficult divorce had changed him, friends said, made him more combative, more willing to fight over small things, more likely to see injustice everywhere. In his judicial work, he was known for being meticulous to a fault, turning simple administrative cases into complex legal dissertations. He believed in the letter of the law, not the spirit. If a regulation said something specific, that's exactly what it meant. This mindset, applied to everyday life, it was a problem waiting to happen. When Pearson saw satisfaction guaranteed, he didn't see marketing, he saw a legal contract. When the Chungs couldn't produce his exact pants, he didn't see a mistake. He saw fraud, deliberate deception, a violation that demanded punishment. The Chungs, meanwhile, were living the American dream. Jin Nam Chung and Sue Chung had immigrated from South Korea. They'd worked hard, saved money, learned the dry cleaning trade. They now owned 3 small shops in Northeast Washington. It wasn't glamorous, long hours in 100-degree heat, dealing with chemicals, pressing clothes, but it was theirs. They were building something, providing for their family. Their profit margins were thin. After rent, utilities, supplies, wages, and insurance, there wasn't much left. They made a living, but they weren't wealthy. When this customer complained about missing pants, they were genuinely concerned. When he rejected the pants they found, they were confused but willing to compromise. $1,200 for one pair of pants? That was incredibly generous, more than 20 times what the pants were worth. But Pearson said no, because the amount didn't matter to him. The principle did. In June 2005, Pearson filed his lawsuit. The Chungs received the papers and couldn't believe what they were reading. The amount claimed $67 million. They thought it was a mistake, a typo. Surely he meant 6,700? Even 67,000 would be outrageous. No, 67 million. The Chungs were terrified. Even if they sold everything, their businesses, their home, their savings, they couldn't pay a fraction of that amount. They needed lawyers immediately. But finding representation was difficult. Many attorneys thought the case was too bizarre, too risky. Finally, they found someone willing to help, but legal defense is expensive. The bills started mounting, thousands of dollars, then tens of thousands. The stress was unbearable. Sue Chung developed health problems, anxiety attacks, insomnia. The fear of losing everything was crushing. Meanwhile, news of the lawsuit leaked to the media, and the media absolutely loved it. Judge sues dry cleaner for $67 million over pants. Perfect, absurd, unbelievable. The story went viral instantly. This was 2005, before Twitter, before Facebook was mainstream. But the story spread like wildfire anyway. News outlets across America picked it up within hours. By the next day, international media was reporting it. Within a week, it had appeared in dozens of countries. Late-night hosts made it their opening joke. Editorial writers couldn't believe it was real. Legal experts were interviewed on cable news, shaking their heads in disbelief. Everyone had an opinion, and overwhelmingly, people sided with the Chungs. A judge, someone sworn to uphold justice, suing a hardworking immigrant family for millions over pants. The outrage was universal. Pearson's response to the media attention. He doubled down. He gave interviews, defending his position. This wasn't frivolous, he insisted. This was about accountability, about consumer protection, about sending a message to businesses everywhere. He genuinely couldn't understand why people didn't get it. But the publicity was terrible for business. Who wants to take their clothes to a dry cleaner being sued for millions? Customers stayed away. Revenue dropped sharply. The Chungs considered settling just to make it stop. But their lawyer advised against it. The case was so clearly without merit that they had a good chance of winning, and settling would encourage others to try similar tactics. So they fought. They couldn't afford to fight, but they couldn't afford not to. But where did $67 million come from? Pearson calculated it using the D.C. Consumer Protection Procedures Act, which allowed penalties of $1,500 per violation per day. Here's his logic. Custom cleaners had multiple locations. Each location had signs. Satisfaction guaranteed. Same-day service. Each sign was a fraudulent statement, each one displayed for years. The math, $1,500 times every sign, times every day they'd been displayed. The numbers exploded. Then he added emotional distress, mental anguish, the value of his wasted time as a judge, car rental fees because without his pants he couldn't. The logic was unclear, but he added it anyway. He considered the precedent, the societal value of accountability, the importance of the case. Total $67 million. Later, after reflection, he revised it downward to a more reasonable $54 million. As the case moved toward trial, Pearson represented himself. He was a judge. He knew the law. He didn't need an attorney. This meant he could file endless motions, write lengthy briefs, bury the Chungs in paperwork, which is exactly what he did. The case file grew enormous, hundreds, then thousands of pages, charts, spreadsheets, calculations. He treated this like a major corporate fraud case. For the Chungs, each motion meant more legal fees, more hours. Their attorney had to bill, more money draining from their savings. By the time the trial date arrived in June 2007, 2 years after the pants went missing, the Chungs had spent over $100,000 defending themselves. $100,000 for pants. Their life savings gone. Their businesses struggling. Sue Chung's health deteriorating. All because a customer refused every reasonable solution to a simple problem. The trial was set. The media was ready. The courtroom would be packed. And everyone wanted to see the same thing. How would Judge Pearson possibly justify $54 million for a pair of pants? June 2007. The case finally went to trial. Judge Judith Bartnoff presiding. The courtroom was packed. Reporters filled the gallery. Legal observers, curious citizens who'd read about the case and wanted to see it firsthand. This was going to be a show. The Chungs arrived with their attorney. They looked exhausted. 2 years of stress showed on their faces. Sue Chung's hands trembled. Jin Nam tried to appear confident, but the fear was visible. Pearson arrived alone, carrying multiple boxes of documents, evidence, calculations, charts. He was ready to make his case. Judge Bartnoff opened the proceedings. She'd seen a lot in her career, but this case was unusual even by Washington, D.C. standards. Pearson began his opening statement. He spoke for a long time, explaining his legal theory, the Consumer Protection Act, the signs, the violations. He showed his calculations, day by day, sign by sign, violation by violation, $1,500 each. He talked about the emotional distress, the betrayal he felt when he saw satisfaction guaranteed and wasn't satisfied, the mental anguish of dealing with this situation for 2 years. He explained that this wasn't just about him. This was about every consumer who'd ever been wronged by a business making false promises. He was fighting for all of them. Judge Bartnoff listened. Her expression was neutral, professional. But those in the courtroom later said you could see it in her eyes, a slight disbelief, a raised eyebrow. She couldn't quite believe what she was hearing. The defense's opening was brief, concise. They pointed out the obvious. A pair of pants temporarily went missing. The Chungs found pants matching the description. Pearson insisted they weren't his but couldn't prove it. The Chungs offered multiple solutions, generous compensation. Pearson refused everything, and now he wanted $54 million. The attorney let that number hang in the air. $54 million for pants. Testimony began. Pearson took the stand as his own first witness, which is unusual and risky. He told his story in great detail, bringing in the pants, the return visit, his shock when he saw the pants they tried to give him. "Those were not my pants," he said firmly. Cross-examination was revealing. "How can you be certain they weren't your pants?" Pearson explained. "The fabric felt different. The cut was slightly different. He knew his own clothing." "Did you have any identifying marks on the pants?" "No." "So you're asking this court to believe you can identify your specific pants among hundreds of similar gray pants based solely on feel?" "Yes," that's what he was saying. The attorney asked about the settlement offers. "The Chungs offered you $1,200, correct?" "Correct." "And you rejected that?" "Correct." "Why?" "Because it wasn't about money, it was about principle, about the sign, about fraud." "You're a judge. Do you truly believe a satisfaction guaranteed sign creates unlimited liability? Pearson argued it did. It was a promise, legally binding. And you believe $54 million is appropriate for missing pants? Yes, based on the law, based on the violations, based on his calculations. The cross-examination continued for hours. Pearson was thorough, detailed, unwavering in his position. When he finally stepped down, the courtroom was exhausted. Jin Nam Chung testified next through a translator. He told his side they'd tried so hard, searched everywhere, found the pants, called immediately. When Pearson said they weren't his, they offered money, even more. Nothing was enough. Did you intentionally give Judge Pearson the wrong pants? No, never. Why would they? Did you commit fraud? No, no fraud. A misunderstanding maybe, a mistake perhaps, but not fraud. Sue Chung testified she was emotional. 2 years of stress poured out. She talked about the health problems, the anxiety, the sleepless nights, the cost. How much have you spent on legal fees? Over $100,000. The courtroom was silent. $100,000 defending against a lawsuit over pants. If you lose this case, what happens? Sue Chung broke down. They'd lose everything. The shops, the house, everything they'd built. The moment was powerful. Even those who'd come for entertainment felt the weight of it. These were real people, real lives, real consequences. Other witnesses testified. Employees from custom cleaners, longtime customers, all said the same thing. The Chungs were honest, hardworking, fair. If there was ever a problem, they fixed it. The trial lasted several days. Documents were entered into evidence. Arguments were made. Rebuttals offered. Finally, closing arguments. Pearson stood. This was his moment to convince Judge Bartnoff that justice demanded $54 million. He spoke passionately about consumer rights, about accountability, about what satisfaction guaranteed should mean. He walked through his calculations again, showing how the law supported his math. $1,500 per violation, per day, multiple signs, multiple locations, multiple years. Your Honor, he said, this case is about integrity, about truth, about whether businesses can make promises they don't intend to keep. He spoke for over an hour, covering every point, every argument. The defense attorney's closing was shorter and more direct. Your Honor, this is about a pair of pants, a pair that may or may not have been lost. There's no way to prove whose pants those were. No identifying marks, no forensic evidence, just Judge Pearson's certainty versus the Chung's good faith. What we know is this: the Chungs offered to make it right repeatedly. $1,200 for pants worth, maybe $40. That's not fraud. That's extraordinary generosity. Judge Pearson rejected every offer because he wanted this. He wanted his day in court. He wanted to punish these people using the legal system as a weapon. The Consumer Protection Act exists to prevent real fraud. Scam artists, criminals, the Chungs aren't criminals, they're a family, immigrants who built businesses and contributed to their community. And because of this lawsuit, they've lost their savings, over $100,000 in legal fees. Their health is suffering, their business is suffering, over pants. I ask this court to see this case for what it is: a misuse of the legal system, an abuse of process, and I ask you to dismiss it and award the Chungs their legal fees. The courtroom was quiet. Judge Bartnoff had a decision to make. Most judges would take time, review evidence, issue a written opinion later, but Judge Bartnoff had seen enough. She announced she would rule from the bench. The tension in the room was palpable. Reporters leaned forward. The Chungs held hands, barely breathing. Pearson sat alone, confident, waiting. Judge Bartnoff spoke. She acknowledged the unusual nature of the case. She reviewed the facts. Pants dropped off. Pants went missing. Chungs found pants they believed were his. Pearson disagreed. There was no way to prove definitively whose pants those were. No evidence beyond Pearson's certainty. She addressed the Consumer Protection Act. Yes, the law allows penalties, but it requires actual fraud, intentional deception, deliberate misconduct. The court finds no evidence of fraud, Judge Bartnoff said, no intentional deception, no deliberate misconduct. At most, an error occurred, but error is not fraud. As for the satisfaction guaranteed sign, she was clear. This is marketing language common in retail. It represents a general promise of good service, not unlimited guarantee of satisfaction under any circumstance. If this court accepted the plaintiff's interpretation, every business with such a sign would face unlimited liability. That cannot be the law. She paused. The court finds in favor of the defendants, the Chungs. This case is dismissed. The courtroom erupted in quiet relief. The Chungs collapsed into each other, crying. Their attorney smiled finally. Pearson sat frozen, stunned. But Judge Bartnoff wasn't finished. Furthermore, the court finds this lawsuit was without merit. The damages sought were absurd. However, the court declines at this time to award attorney's fees to the defendants. That last part hurt. The Chungs had won, but they wouldn't recover their $100,000. She banged her gavel. This court is adjourned. And just like that, it was over. Media swarmed the courthouse. The Chungs didn't want to talk, just wanted to go home. Their attorney spoke for them, calling it a victory for common sense and small businesses. Pearson told reporters he was disappointed and might appeal. He did appeal. The appeals court was not sympathetic. They upheld the decision completely and went further, criticizing Pearson for filing a frivolous lawsuit that wasted court resources. They also suggested judicial oversight might be appropriate. Should someone who files such a lawsuit continue serving as a judge? The D.C. Commission on Judicial Disabilities took notice. They investigated, and when Pearson's term expired, it was not renewed. His judicial career was over because of pants. Winning the case didn't mean winning in life. For the Chungs, victory came at a devastating cost that would echo for years. They'd spent over $100,000 in legal fees. Every penny of their life savings, accumulated through decades of 14-hour workdays, breathing chemical fumes, pressing clothes in sweltering heat, gone. They filed a motion to recover those fees from Pearson. The lawsuit was clearly frivolous, they argued. If any case deserved sanctions, this was it. Judge Bartnoff denied the motion. While the lawsuit lacked merit, she couldn't definitively say it was filed in bad faith. Pearson genuinely believed he had a case. The Chungs appealed, desperate. The appeals court agreed with Judge Bartnoff. Pearson was wrong, but not maliciously wrong. The Chungs would never see that money again. The financial devastation was catastrophic. But the damage went deeper. The publicity had been relentless. Even though they'd won, even though they'd been vindicated, people remembered the headlines, the controversy, the massive lawsuit. Who wants to take their clothes to that dry cleaner being sued for millions? Customers stayed away. Revenue plummeted. Within 3 years, they were forced to close 2 of their 3 locations. The businesses they'd built with their own hands, their piece of the American dream, dismantled. Sue Chung's health never recovered. The 2 years of constant terror, of sleepless nights wondering if they'd lose everything, had broken something fundamental. Anxiety became chronic. Depression set in. Health problems that would follow her for the rest of her life. Jin Nam kept working because what choice did he have? At an age when he should have been thinking about retirement, enjoying the fruits of a lifetime of labor, he was rebuilding from ruins. This was supposed to be the American dream. Come to a new country, work hard, build something, contribute to your community, provide for your family. They'd done everything right. And still, they'd been crushed by someone who weaponized the very legal system meant to protect them. For Pearson, the aftermath was different. Losing his judicial appointment was a blow. His career, his identity, tied to being a judge. But in rare interviews afterward, he maintained he was right. The Chungs committed fraud. Satisfaction guaranteed meant something. Businesses should be held accountable. He didn't understand the outrage, why people sided with the Chungs, why they didn't see his perspective. The math was correct, he insisted. The law supported it. Yet people called him the villain. He tried to find work, but his reputation preceded him. Who hires the pants lawsuit judge? He largely disappeared from public life. The case became infamous in legal circles. Law schools taught it not as good legal reasoning, but as a cautionary tale. This, professors would say, is what happens when someone confuses legal technicality with justice. This is why proportionality matters. This is why we must consider the human impact of our legal actions. The case also became political ammunition. Those advocating for tort reform pointed to it constantly. See, this is why we need lawsuit limits. Others argued the opposite. The system worked, they said. Pearson filed a ridiculous lawsuit and lost. Justice prevailed. Both sides used the same case to support opposite conclusions, which might tell us something about the case itself. For the legal community, the case raised uncomfortable questions. Pearson was one of their own, a judge, someone who should understand justice, who should use the law responsibly. And he'd done this. It made people wonder, if a judge could file such a lawsuit, what does that say about the legal system? Maybe the law was too complex, too technical, too disconnected from common sense. Or maybe it was simpler. Maybe one person, consumed by anger and rigidity and a need to be right, could abuse any system. The pants themselves, the actual gray pants at the center of everything, disappeared into history, perhaps still hanging in someone's closet, perhaps donated, perhaps thrown away. Somewhere there's a pair of gray pants worth about $40 that destroyed a family's savings, ended a judicial career, and made international headlines. All because one man couldn't let go. Years have passed since the pants lawsuit. The case closed in 2007, but its impact lasted much longer. It's still referenced today, still discussed, still taught. Remember the pants lawsuit, people say, and everyone knows exactly what case they mean. So what can we learn from this bizarre chapter in legal history? First, about the law itself. The law is a tool, a powerful one. Like any tool, it can be used properly or abused. Pearson had legal knowledge and used it as a weapon against people who couldn't defend themselves easily. The Consumer Protection Act that Pearson cited was designed to protect consumers from real fraud, from scam artists who deliberately deceive people. It wasn't meant for minor disputes over dry cleaning, but Pearson found a way to manipulate it. He found the mathematical loophole, the technical interpretation that could turn $40 into $54 million. That doesn't mean the law is bad. It means laws require wisdom and application, not just technical correctness. Second, we learn about proportionality. Justice isn't just about being technically right. It's about fairness, about punishment fitting the offense, about solutions matching the problem. Even if we accept Pearson's premise that the Chungs made a mistake and broke their satisfaction guaranteed promise, does that justify millions in damages? Of course not. The Chungs offered $1,200. That was proportional. That was fair. That would have made Pearson whole 30 times over. But Pearson wanted vindication, not compensation. He wanted to punish, not resolve. Third, about conflict resolution. The best solutions aren't always in courtrooms. Most disputes are better solved through compromise, through conversation, through letting go. Pearson could have accepted any of the Chung's offers, could have moved on with his life. Instead, he spent 2 years fighting filed thousands of pages of documents, stood in court for days, and in the end he got nothing. No money, no pants, no vindication, just a damaged reputation and a lost career. Meanwhile, the Chungs got nothing too. They won the case, but lost their savings, their health, years of peace. Nobody won. Everyone lost. Fourth, about the immigrant experience, the Chungs came to America with dreams. They worked incredibly hard, built businesses, contributed to their community, and they were nearly destroyed by someone wielding the legal system as a weapon. They couldn't afford the lawyers they needed, couldn't afford the time away from their businesses, couldn't afford the stress. The case showed how vulnerable small business owners are, especially immigrants who may not fully understand the legal system or have resources to fight back effectively. Fifth, about obsession. Pearson's quest started reasonably enough. He'd lost pants, wanted them replaced. That's fair. But he couldn't let it go. When the Chungs found pants he didn't believe were his, he could have accepted compensation and moved on. Instead, he let it consume him. The case became his mission, his crusade. He lost all perspective about what was reasonable, what was proportional, what was just. In pursuing being right, he lost sight of what was good. Sixth, about public opinion and media. The case became a spectacle partly because it was so absurd. $67 million for pants? Perfect headline material. The media attention destroyed the Chungs' business, even though they eventually won. Once you're labeled the dry cleaner being sued for millions, customers stay away, regardless of the outcome. Pearson became a symbol of lawsuit abuse, a punchline for jokes. The media attention defined both parties in ways that outlasted the case itself. Seventh, about the legal profession. Lawyers and judges have enormous power. They can help people or hurt them. They can use their knowledge to resolve conflicts or create them. Pearson had that power and misused it. His fellow legal professionals largely condemned him, but the damage was done. The case reminds us that legal knowledge carries responsibility. With great power comes, finally about human nature. We all get angry sometimes. We all feel wronged occasionally. The question is, what do we do with those feelings? Do we pursue vindication at any cost? Do we let anger drive our decisions? Do we prioritize being right over being happy, being justified over being at peace? Pearson chose vindication. He chose being right. And it cost him everything: his career, his reputation, years of his life. The Chungs wanted to run their businesses and live quietly. They got dragged into a nightmare they didn't deserve and couldn't escape. And the pants, still missing, still unidentified, still worth about $40. This case will be remembered for generations as a cautionary tale. Law schools will teach it. People will reference it. It will be the answer to the question, what's the most ridiculous lawsuit ever filed? But it's more than ridiculous. It's tragic. 2 families destroyed over nothing. A judge's career ended over pants. $100,000 spent. $100,000 not recovered. All because compromise failed. Because anger won. Because someone couldn't let go. The Chungs are still in business, operating their one remaining dry cleaning shop. They're older now, still working, still dealing with the aftermath. Pearson lives quietly, out of the public eye, presumably still believing he was right. And somewhere, someone is wearing a pair of gray pants, maybe the original missing pair, maybe not. We'll never know. But we know this: those pants, wherever they are, cost far more than $67 million when you count what was lost: savings, health, peace, careers, years of life, trust in the legal system, all for the principle of being right. This has been the true story of the $67 million pants lawsuit, a case that showed us something about law, about justice, about human nature, and about the price of obsession. Thank you for watching. If you found this story fascinating, there are hundreds more like it, cases that reveal the drama, the humanity, and the lessons hidden in courtroom battles. Subscribe for more true court stories. And remember, sometimes the best way to win is to let go.